Katoa, now. Now, mai piki mai haere mai. Welcome to this hearing in the RSA Whare. This is a hearing by Westland Mineral Sands to construct and operate sand mine near Mananui, also near Ruatapu, appropriately named because there are two special places in close by, Lake Mahineapua and Tuwharewhare. So we, of course, in that context, acknowledge the takiwa of Te Runanga o Ngāti Waiwai and Te Runanga o Mark Carfield. So, kia ora. So if you're in the wrong place now, you'll definitely know. And I want to welcome you all to this hearing and to start by introducing ourselves at the table. And I have to apologise to the people behind me. The arrangement of the room means I'm speaking away from you, but I'm sure you'll hear me. So my name is John Marson, and I come from many places in the North Island, but now principally resident in Tamaki Makaurau. And I have about 35 years experience of resource management lawyer. And I tend to be involved in hearings of complexity, but my main work is actually as an advocate. And on my left is Tim Vile, a planner from Otago with considerable experience, and who also sat with me on the Barrytown mining application. And on my right is Mark Geddes, who also appeared at the Barrytown application, but in a different capacity. And Mark is a planner working in a large part in the South Island, throughout the South Island. And so you have a lot of tremendous planning experience for this hearing. And just two preliminary comments. The Resource Management Act contains some provisions where Parliament has expressed two things. The first is the desire for the hearing to be in public. And that has now taken an interesting contemporary shape in that part of the hearing is recorded and placed on YouTube. So I haven't searched for myself on YouTube for the many hearings that I've conducted, and it's quite daunting to think that you're immortalised in these hearings, but that is the reality, so I think I should tell you that. And the second thing that Parliament encourages us to do is to adopt a lack of formality. And the reason for that is to make everyone comfortable in these types of hearings, because this is not a contest of ideas about who should win or lose, but how activities can be appropriately conducted or whether they should be conducted at all. And that is partially a community enterprise and is not intended to be a adversarial system, which has some consequences I'll explain to you as I go through. So while the idea of informality is a good idea, there is some structure that's needed to these hearings and some formality so that we can get the business done in an appropriate and respectful way. And I'll come to those matters in due course. What I'd like to do now is to first of all just acknowledge some of the people who have made it possible for this hearing to be conducted. And I'll start with the most important first, which is the gentleman under the screen there, Tin Nguyen, who's helped us with logistics. And this morning I've met Kate Fleming, who's also there. So they're getting the practical side of things organised, and letting me know about things that need to be addressed or not. And then we acknowledge the council staff that are in the place of being the regulator. And for the West Coast Regional Council, because this is a joint hearing, Rachel Clark is the reporting officer. And I say officer because she is in fact an employee of the Regional Council. And for the Westland District Council is Ms. Melissa McGrath, who is not an employee of the council, but a consultant planner. And the lady next to her, I don't think I've met.
My name's Deborah Patterson.
Deborah Patterson. And you're a senior planner at WCRC. So the council in its role as regulator has provided some reports which are a contribution to the information, and we need to decide this matter. But they don't get any halo status by virtue of coming from the regulator. We are here to independently form an opinion about the evidence and the law. And on my right, we have the applicant, who is always given a place at the table since it is their application. And Ms. Booker, and if you could introduce your team, please.
So legal, I'm Miss Booker and I'm legal counsel for Westland Mineral Sands. And to my right, I've got Miss Barry, who is also part of the legal team. And then what I'm going to do out the back, guys, is actually get you to stand up because it's quite a big room, if that's all right. So we've got Duncan Hardy, who is a company representative. Yeah. We've got Ray Mudgeway over here, also a company representative. We've got the company chair, Debbie Birch. Tom Ritchie will be joining us online, and we've got Tim Chase, who is operations of the company as well. Karen Go is the mine planner, and she'll be joining us online. We've got Duncan Ross, who is environmental, part of the environmental team, again for Westland Mineral Sands. And then from the consultant crew, we've got Nick Fuller, who's transport. John Farron, who's noise. Jens Ricker, hydrology. Dr. Mike Fitzpatrick, who is water quality. We've got Mr. Andrew Hurley, geotechnical online, and Mr. Ridley, sediment online. And then we've got Dr. Vaughan Keating, who's an ecologist. We've got a reviewer, Dr. Bramley, who's online. We've got Naomi Crawford, who's landscape. We've got India, who's archaeology, and she's online. And so is John Bellinger. And then we've got our planner, Adrian Lowe, who's over here. So it's quite a big team. And I think it might take up most of the room.
Thank you. So just for those submitters who are not present but maybe following this virtually, obviously we welcome and we'll have questions and look forward to your contributions during the course of this hearing. So just in terms of the kaupapa of the hearing, its process, how we frame it, I've explained to you the informality, and I just want to mention briefly something which is pretty common sense, which is that everyone gets a fair hearing and is respected in terms of the process, and we exercise civility, which is an important virtue in the course of the hearing. And if you get a frown from me, don't worry, I might be just thinking, but I will say something if I think I need to take control. Site visits, we are proposing to do a site visit, weather permitting, at some point on Friday, and possibly, and certainly a field trip to a mine that Westland Mineral Sands is operating at Cape Foulwind. And the purpose of that visit is substantial and not just simply to obtain a helicopter ride across the beautiful Rutini, which is to understand in situ how these operate and features and some things about landscape restoration and so forth that could possibly be revealed by an up and running mine. And a lot of these types of facilities, because of their necessarily impactful operation, are useful to understand in terms of how they operate, the size in any open area, and how it's functionally managed to give people a sense of how that works. So those two things will occur, and on the site field trip will be accompanied by Melissa McGrath. Now, only the panel has the power to ask questions, but if there are questions that arise that you think we're missing, then we're very open to you approaching Kate or Tin and saying, look, I would like them, or I'm unsure about this, and I think this needs to be asked, and we'll consider that and ask questions. But there is no formal opportunity for anybody but us to ask questions. I think it's fair to say that my style is quite inquiring, and that's because typically I'm less informed than the expert and confused about a topic, and I want to arrive at a point of understanding. And so it's not that we're trying to catch anybody out, but that we're trying to understand the underlying reasons for our uncertainty or differences between experts in order to make the best possible decision. So that's the spirit in which we come to our questioning. But you might find that it does go on, and my style is very direct, engaging, following on, as opposed to a formal list of questions. And I'm sure my fellow commissioners will be similar type. In terms of facilities, the fire breaks are indicated by those signs. So if there is a fire, then we know where to go, or another emergency. There are toilets through there on the left. This is obviously a special place to the people who own it and operate it. So obviously respect the fact that it's a special place for them. And in terms of breaks, I think the schedule which Tim has constructed has us typically having a lunch break at 12:30 and an afternoon tea break at 3 today, but we'll start earlier on the other days at 9 a.m, in which case there'll be a morning tea break at 10:30. And that gives people an opportunity to just rest, because often the information we receive is quite dense. So that, I think, covers all of the matters. So as is typical with this process, the applicant goes first. Then we hear from the submitters. Then the council officers are then in a position to speak to their recommendations and identify anything that has changed or inform them. And then the applicant has a right of reply in relation to matters arising from those things. So that's the basic structure. And in relation to conditions, we will from time to time look to the conditions to see whether or not a point has been addressed adequately in the way that an expert has intended, and things of that nature. And that is sometimes described as a bit of a running dog, in the sense that the conditions are always in a state of evolution. So to the extent that there is a version control problem, we will struggle with that, just like anybody else. So we do ask that documents be given headings that indicate both version and time, so that we can look back and not look at the wrong document, because it is a characteristic of these hearings that you get a lot of paper. So with that, that's my concluding introduction. I think ChatGPT has told me I haven't done enough, but I'll just turn that off and invite Ms. Booker to open the case.
Thank you. Just a couple of administrative matters before I confess that I've missed a key member of the team. So Ms. Mackay, or Heather Mackay, she's the consents manager. She's not preparing evidence or presenting to you, but is obviously a very key member of the team in terms of bringing it together. So sorry, Heather. And then just in terms of administrative matters, we have circulated via TIN what we've called a summary statement from our expert witnesses. We do that to reduce the paper, and those experts will speak to those today, so they're not expected to be pre-read, but they have been circulated electronically to everyone. We haven't brought paper copies along of those, and I'm assuming you've got those available to you. They were circulated last week.
I haven't printed out one out yet. Did you send this morning?
Or last week?
No.
From Kelsey Barry. So with the pre-circulated summary statements, because
Just received this one at 6:30 a.m. this morning.
oh, that's legal submissions.
Yeah, is that the
It was there. Do you want to resend that email to Tim again on Friday?
we can print it out
Yeah,
today. Yeah.
it's mainly so that there's a public available document, but those will be spoken to today.
When will we receive those?
I was hoping you had them, but I think you'll receive them very shortly. So with that, what we've done to assist the hearing is we have had the applicant team write down what they're going to say in terms of their summary onto a piece of paper. And as part of those summary statements, there's been a significant amount of discussion and engagement ongoing with submitters, and they've updated some aspects of that. For example, the planning evidence or the planning summary statement includes a revised set of condition of consent, which are dated 30th of May. And so to also assist that process, we have pulled out from across all of the evidence, so they're not new images, a graphics bundle of sort of the key images that we're expecting the experts will speak to you. And in anticipation that this was not going to work, we've actually also printed that, and we've put a copy on the submitter table, on the officer's report table, and you've got a copy. What we call it is a graphics bundle. It's simply key plans that experts have indicated they're going to listen to, are going to speak to. And at the back of that, at number 10, we've also put the latest draft set of conditions dated 30th of May that are attached to Mr. Lowe's summary statement, and the scheduled plans with those conditions. It's simply a reference document. It's all material that's been pre-circulated. But just to assist if our graphics don't work on the screen.
Right, sorry, I just got slightly distracted. When are those summary statements coming in?
So that the statement of evidence from on the expert from Westland Mineral Sands, I downloaded and have it on here, so ready to be shared when anyone's speaking about it.
Oh, so on Friday, an email sent a bunch of summary statements in a graphics bundle and indicated that these did not expect to be pre-read, but were going to be spoken to at the hearing. Have you got that email from Kelsey Berry?
Yep.
Yeah. So I think if you could circulate that to the people who need it, the commissioners in particular. Yeah.
Okay, so after the legal submission.
And they can go online, publicly available as well, so that everyone's got access to that information. Yeah. As a precaution, Ms. Barry tells me we have printed 3 of each of those summary statements in case we needed a paper copy. The other thing I just remember that was also included was the 2 PowerPoint presentations that Mr. Hardy and Mr. Mudgway will speak to in that graphics bundle.
Yep, in the landscape. I will have
Probably,
This one, ready to be shared on the screen. Once, when anyone wants to talk.
yeah, no, we're, what we would like is to actually download the electronic copies of what Ms. Booker is referring to so that we've got it in our database. If possible. I don't know whether that's simply there on the website for us to download or whether you need to email it to us.
I will email it right away for now. And print it out into copy as well.
I'm not sure we
Don't need to print copies, no. I'm trying to avoid paper, yeah. I think if you forwarded Miss Barry's email, that would be sufficient because it's got the 2 PowerPoint presentations, all of the summary statements, and what we've called the graphics bundle, which is a collection from the evidence of the images we think we will most likely speak to during the course of the hearing.
Yeah, so at some point during your opening, we'll just, whether it's at the start, in the middle, or the end, check our emails to make sure we've got them and put them into our system.
Yeah.
So that we've got them correctly numbered and.
Yeah. They're small documents, so I'm anticipating you'll be able to, yeah. The other thing that you should have, and we might just check the tin on this as well, is an electronic version of the legal submissions. But I've also printed a copy this morning at the iSite for you, so you've got that in front of you in paper copy, but they'd be available for the public to be put on the website.
Perfect.
Yeah. Cool. So I think that's all I had in terms of administrative conditions. I'm aware this morning that we've received a letter from Putini Ngāi that we haven't got across yet as a team that we anticipate we'll talk to tomorrow.
Yep.
So that's a letter that indicates that they've moved from opposition to neutral and have some further things that they'd like to see in conditions. So we will discuss it as a team tonight and be in a position to comment on that tomorrow.
So to the extent that requires any other witness to come back to address, then that's fine.
Thank you. We've sort of planned the day, so it looks like Mr. Rick will be first up tomorrow and he will be the first witness that would need to speak to those matters. The other thing I should just mention is there's been a bunch of engagement that's been occurring since the submissions were made and the evidence was filed, and any engagement has been reflected in those summary statements that you'll receive and that the experts will speak to today, except for the letter from Ngāi. But other than that, I was going to work through my legal submissions. I was just going to ask, knowing Sir, your directive nature and asking of questions, whether you could refrain from questions just for my first case summary, and then after that I'm happy to engage as I work through the rest of the submissions.
I'm happy to refrain.
Thank you. Nāia te mihi kati mana whenua, nāia te mihi kia koutou tēnā tātua. May it please the Commissioners. Westland Mineral Sands Co Limited seek resource consents to establish and operate a mineral sand mine operation at Mananui. The application is targeting extraction of heavy minerals, ilmenite and garnet, and gold. The heavy minerals have been deposited thousands of years ago in strand lines and now sit under the site, which has been modified through vegetation clearance and other farming practices. The site has been extensively drilled, the geology and mineralogy well characterised, and it is, in Mr. Hardy's view, a farm with one of the region's largest in-ground deposit of minerals. More generally, mining is an important industry for the West Coast. It accounts for 10.5% of the region GDP, compared with 0.8% for the national economy. In the last year, West Coast economic growth has been strong and is expected to be a result of strong export returns, and growth is expected to continue as the region focuses on the extraction of important minerals such as ilmenite and garnet, such as here, which are in high demand globally as countries seek to transition to low emissions future. Nationally, the potential opportunity for the West Coast to deliver economic benefits and position New Zealand as a sustainable producer of in-demand minerals has been recognised. A mineral strategy for New Zealand to 2040 was delivered in January this year, along with a critical minerals list, which includes minerals sought to be recovered as part of this project, ilmenite, garnet and gold. The strategy contains a vision for a responsible and sustainable mineral sector and seeks to double the value of New Zealand's mineral exports to 3 billion over the next 10 years, including by realising new and critical mineral opportunities. West Coast is explicitly recognised in the strategy for extracting gold and heavy mineral sands, titanium, garnet, zircon and rare earth elements. Growth from mineral resources is also a local vision. Te Whanakitanga Te Tai Potini West Coast 2050 strategy, which is a collective community commitment supported by all local authorities in mana whenua, identifies the competitive advantage the region has in the mining sector and in the natural resources which can be utilised to support the regenerative economic future while protecting the environment for future generations. The applicant, Westland Mineral Sands, is a proud West Coast company seeking to be part of this growth and diversification delivery and create a positive economic impact in the West Coast community with minimum environmental impact. The development of a sustainable shipping network and the revitalisation of regional ports are seen as critical to this and to establishing an intergenerational and environmentally responsible mineral sands industry for the West Coast. As part of this project, the applicant will continue to invest in coastal shipping via Greymouth Port, where the company has a long-term lease, and this will further promote infrastructure resilience for the West Coast. Through this application, the applicant is seeking to provide diversification of product and enable scale necessary to supply the global market for critical minerals. It represents a critical second phase of growth beyond the successful pilot plant at 9 Mile near Westport, which has seen the applicant grow from 2 to 60 full-time employees over the last 2 years and become active in that community. The jobs that will be created by this application are important. They will be significantly higher than a median West Coast salary and are expected to be largely filled by local residents based on the applicant's experience at its 9 Mile site. The positive benefits of creating jobs and bringing young people and families to this region and subsequent benefits to local suppliers, as well as the diversification to the minerals extraction sector, has come through clearly in submissions in support. These views from the local community should not be lost in this process, and I've set out a summary of the supporting submissions and some extraction submissions in Appendix 1. I don't plan to read through those, but they are available. The applicant's commitment to the environment is clear when you read the pre-circulated evidence from company representatives. The mining footprint is within a highly modified farmland used for dry stock grazing and dairy support, and is in a zone where mining is expressly anticipated to occur in the Westland District Plan. However, from the outset, the application has been designed with its sensitive surrounding environment and important cultural context at the forefront of considerations, and with a view for long-term environmental restoration. Mr. Chase will explain that the mining methodology and equipment was selected for better hydrological outcomes, more controlled material recovery and a reduced mobile fleet. Nighttime operation equipment has been minimised and careful consideration given to matters such as management of lighting and noise. The plant area was fixed in location once it had considered sensitive boundary as well as public and neighbour views. There are distinct geological phases which affect concentrations of mineral sand deposits and gold on the site, with the highest concentrations occurring along the eastern boundary. This boundary adjoins to Whariwhari, Mananui wetland area, which is culturally significant, being Ruatapu, sacred, and taonga. Mining is set back a minimum of between 22.4 and 132 metres and will avoid these areas, as well as avoiding the adjoining raised area of vegetated land on the site, which you'll hear us call the Eastern Escarpment area, which is considered by Dr. Keating to be a significant natural area. This comes at a cost of 18% of the site's resource. The Lake Mihinapua Management Plan seeks to protect and enhance Mihinapua as a significant ecological area, particularly as kohanga for mahinga kai and taonga species, and to improve the cultural and ecological health of Lake Mihinapua through wetland and riparian planting, protection, fencing and management of connected waterways, particularly to Whariwhari, which is the Mananui Creek. To preserve the cultural significance, ecological value and Indigenous biodiversity of this area long-term, Mr Hardy will address how the applicant will offer the area of the Mahinapua wetland within the application site to mana whenua. In addition, the new fenced ecological reserve, that is an area of 4.75 hectares of forest restoration adjoining that wetland, and 2 new constructed wetlands will also be offered to mana whenua. And a condition has been pro-offered, which includes a minimum area of 28 hectares. This will have positive biodiversity effects beyond the life of the mine. A public walkway linking the dock-managed Mahinapua walkway with the Mananui walkway to ensure ongoing access for walkers, cyclists, bird watchers and the wider community is also being investigated. You'll hear from experts today and tomorrow that the application has been designed to ensure a sustainable mining operation that protects the environment, cultural values and matters of national importance and seeks to maintain amenity values. It is not within, the application site is not within the coastal environment. There are no outstanding natural features or landscapes within the mining area. Adverse effects on the proximate O&L areas will be avoided, and conditions are proposed to ensure the effects on archaeology and historic heritage are not adverse. With respect to ecological matters, adverse effects can be avoided, minimised and remedied as appropriate, such that the overall level of effects is not more than minor. Comprehensive rehabilitation, which accounts for settlement, will return the land to livestock grazing. The altered topography of the land will provide opportunities for the enhancement of existing pasture, land contouring and drainage patterns. Mr Mudgway will explain that from the earliest stages of the application, meaningful engagement has been undertaken with iwi, and we've talked about the Runanga, Ngāti Waiwai and Makawhio, residents, landowners, environmental groups and other relevant stakeholders. Public drop-in sessions have been held and the public notification was requested for the community to be heard. It is significant that several persons that were directly served with the application did not submit. And I'll just pop them in a footnote. The majority of the submissions received were in support. Meaningful consideration of the submissions in opposition has continued to occur, with further engagement and amendments being made, which is detailed in the pre-circulated evidence. The most significant being the creation of an alternative mining path to ensure further testing of the mining operation prior to nearing sensitive areas along the southern and eastern boundaries. Clarifying that the 2 man-made drains to Whariwhari will be blocked to ensure there are no discharges influenced by mining activities to surface water. Substantially increased water management and monitoring to ensure the protection of Whariwhari. Changes to management plans and specifications of the machinery to be used, which will make material difference to the level of effects experienced for neighbours as well as fauna. Mr Lowe has included an updated version of conditions dated 30th of May, which includes some additional changes following subsequent discussions with representatives of Te Ruranga o Ngāti Waiwai and Te Ruranga o Makawhio, the Department of Conservation and the New Zealand Transport Agency. As detailed in Potini Ngā Tahu's submission, they would like to ensure appropriate mitigation measures and controls are in place so cultural values are protected. Ongoing engagement has occurred with them since that submission, and new conditions are offered for increased water management and monitoring. Matters raised in the NZTA submission have been resolved through amended consent conditions offered, and I understand a letter's been tabled to that effect. What I'm talking about here is in the summary statements, there is an update of what's occurred since the evidence was lodged, and it captures these further changes. The application has been comprehensively assessed by experienced and reputable technical experts, additional evidence provided at the request of the councils and peer reviews completed, including by the applicant in response to submitted concerns. The sand mining proposal is of relatively short duration, 10 years of mining. It's transient in that it moves 6 metres a day or 170 metres per month, and it is limited in scale through progressive rehabilitation. The operation will have significant positive effects, no more than minor adverse environmental effects, and is consistent with the outcomes sought in the relevant planning documents applying to the application site. The application in my submission will enable the wellbeing of people and communities while achieving the matters in section 5, subsection 2 of the RMA. It's submitted the sustainable management purpose of the RMA will be met by granting of the consents as sought. I now will turn to matters to address in submissions, and I'm happy to have questions, and I'm also happy to have questions on anything that I've spoken to now as appropriate.
No, I think we'll let you just go through, but we might have the odd question as it arises.
Thank you. And one thing I might just say is you won't have had an opportunity to look at it yet, and we're not expecting that you will, but there's been a substantial restructure of the water management and monitoring conditions as a result of direct engagement with the planners from Potini Ngāi Tahu. So you will see now that there's at least 12 months data in terms of baseline. They've got what we call a commissioning study pit, which is going to occur and is set out in all of the schedules, and we can talk through this. I wonder if it's useful to refer to it as we go, so you've got a bit of an idea. So if we have a look at, in terms of the bundle, we've got the draft conditions of consent. And if we look at schedule 6 to that, which is 16, tab 16, there are 3 images here that are going to be attached or proposed to be attached to conditions of consent. The first image now shows an upstream and downstream surface water monitoring. You can see by SW1 and SW2. The second image shows a commissioning study pit outline, where there's going to be a series of studies completed in terms of at least 3 months of monitoring in the area that has been sort of boxed off as pink before it goes further south towards Tūwhariwhari. And then on top of that, if you have a look at the next image, there's a series now of permanent piezo's that are regularly placed across that eastern boundary. So all of this is quite new, I think, and you won't have read about it. And we do plan to address it when we speak with the technical experts, but I just want to flag that that's all been going on since the evidence has been lodged.
Yeah, so my reaction to that is that it would be really helpful for Mr. Reka to go through and explain both what is going to be done and the rationale for it, how it arose. So that we both get it, but also the whole the hearing.
And gets it. No, I understand that. And Mr. Reka was involved in the engagement with Potini Ngāi Tahu and Department of Conservation. So he was across all of the reasons and the concerns that were raised and why things have been done the way they have.
Right. Yeah. And so in terms of monitoring post-construction, these items and monitoring sites will continue to operate and report results and things.
We can get Mr. Reka to speak through them all, but the ones along the eastern boundary are permanent. So I don't know how long they stretch to in terms of the term of the consent, but but in terms of the new commissioning study, that's something to inform as you go. They're temporary along that southern boundary.
And are you going to speak to refer to anything in here about the removal of drainage from the farm as part of the arrangement? I think that you mentioned that earlier.
Correct. So that has also been as part of the engagement with Potini Ngāi Tahu is a real clarity around currently there's man-made drainage that drains farm into the wetland. That will obviously be blocked, and Mr. Reka will speak to that because there's a point at which it connects with the groundwater that will be blocked and will remain blocked until they're out of that water management area. Longer term, Dr. Keesing can speak about how those areas won't be permanently blocked, but rather will present as long-term wetlands, and he can explain the reasons around and why that happens, and that works in with the final rehabilitation plan, which also slightly distributes the water in a different way to ensure the ongoing protection of Tūwhariwhari.
Okay, so I'll signal some questions for those experts now because it's a
Perfect.
point to do that.
Yeah.
We haven't visited the site. I don't understand the contours. It may be, and I don't know, that the natural drainage of the land on the eastern section is into to Whatawhati, or it may not.
No.
It may be that the drains have been constructed to improve land production, but actually it's quite an unnatural outcome. And it seemed to me that if, as one of the permanent solutions, there was an rearrangement of hydrology with, for example, wetlands on the periphery, which you mentioned Dr. Keesing was going to talk about, there may actually be some water quality improvement outcomes associated with that change in hydrology.
Correct.
On the rather basic assumption that if you've got dairy farm drains running into Whatawhati, I think Dr. Fitzpatrick, Fitzsimons, what was
That'll be
Fitzpatrick
Yes.
said that there was elevated organic material in the water quality. So I don't know whether.
yes, although I think that's something that might be more widespread on the West Coast because of the materials. But what you're talking about is being directly discussed, and the experts are completely across and have considered all of those matters. So I will flag to them. And it might be helpful also to have a look at tab 5, which is in Dr. Keesing's evidence. And it does show the water table and the sort of the land on a cross section. It's quite useful to understand when you're on the site as well in terms of where the water drains, which is obviously naturally away from the wetland. And Mr. Eek will be able to address the limited purpose of those man-made drains in any event.
Okay, because that in my mind, that was an issue that was working through.
It's also a matter that can have long-term improvements to the area, which everyone, the expert team are very alert to.
Yeah.
Yeah.
And I did think that the conditions for the water management plan lacked a certain degree of statement of objectives that said these are the outcomes that we want to achieve and so forth.
Yeah.
Presumably that's been looked at.
And that was a concern of Mr. Lowe as well, who has come into this process after the application was lodged. Yeah.
So I guess the question I have for every expert is, what do you say are the main things you're trying to achieve? You describe in your evidence, and how is that demonstrated by a statement of objectives in the conditions?
Yeah.
Because I'd like, if there is to be a consent planner to pick it up and know exactly what they're expecting to be achieved by the management plans and all those sorts of things. So, well, there's one set of conditions I use to evaluate them, and I didn't feel that you could read their conditions and know anything about the material that Mr. Recker and others have tried to achieve in their draft management plan.
Yeah, I think, and we'll talk to these, there's been quite a large restructuring of those conditions. So there is, if you're looking at tab 10 now, they've got the water management, monitoring and mitigation plan put together with a more comprehensive set of objectives. We will still review based on the comments you've made. And then that, I think, has assisted in making it clearer with the objectives. But what we can do is because we'll be working through a few things tonight on the back of Patani Ngaitahu's comments as well, and we can reconsider the conditions at the same time. But I think one thing I would just flag is the conditions that were circulated as part of evidence with respect to water management and monitoring look very different in the latest set of conditions from condition 24.
Thank you. Thanks for signalling that.
Yeah.
One other point while it's in my... there seemed to be some debate, as I recall it, amongst the experts about whether or not a consent was necessary.
Correct.
Some of those arise because the way, for example, a freshwater standard is drafted, you have to propose an effect. It's not only a distance, it also has to
Correct,
propose
it's got to have a water effect.
And what I would like in the first condition is some clarity about what consents are not being sought or granted as part of the general statement, the general condition. So, for example,
Everyone's clear on that.
everyone's clear that this, because then we don't actually have to make a determination about whether a consent is required.
Correct.
We're not being asked to
Yeah.
approve that.
Yeah.
And equally that then frames whatever is being approved. And I think that needs to be upfront.
Yeah, I think that's the point. Well, that's definitely not in there at the moment.
Yeah, so that someone looking at this doesn't have any illusion that if an event is happening that breaches that regulation,
Consent hasn't.
you're in the space of acting unlawfully. You're not. This is not an approval for it, and I felt that that needed to be upfront for some of the sensitivity of these resources.
Point taken. I think it's a good idea. Yes, the disputes, as I understand it, relate to what are the wetlands in relation to whether there's any wetlands within the pasture area that would trigger the need for the consent under Regulation 45D. I understand that there's consensus with the Regional Council and with the applicant that the two whare wouldn't be in any way altered or drained. So we're not seeking consent for that aspect, and that was why there was a precautionary consent sought. But I agree. I think we need to be very clear that consent hasn't been sought or obtained.
Yeah.
Because there's conditions within that condition set that basically don't allow you to go any closer until you've demonstrated that that outcome will be achieved, that there will be no impact.
You can have conditions that make sure that you don't get into that territory, but it's still important to be clear that we're not authorising it.
Correct. Yeah.
I think we probably, depending on where the questioning goes, we may be competent to deal with the question of whether there are any natural inland wetlands that would trigger a need for consent. But if we're not clear about that, then simply it is not a consent for that.
Right.
But I'm not going to shy away from discussion about that topic.
Yeah, and since I just can't recall if it was in the earlier evidence, but there's obviously been a lot of survey work done since submissions have been received as well on the site, looking at areas that were flagged as potentially wetlands. Dr. Keating's been on site and checked them all, and then we've had that peer reviewed. So the applicant is confident of its evidence and that a consent's not needed.
Yeah, because I think we have to be approving a mining sequence and pathway according to the maps.
Yeah. And
so we can't, in a sense, sidestep the question, would that...
Correct. It's in, well, yeah.
But for the other ones that I was speaking about...
Yeah, this would apply regardless because no consent's been sought.
Yeah, there's others where it's the functional, how much impact are you having, or where we just need to make it clear when we've gone.
No, I understand that. The applicant position is very strongly that it will not be draining or changing the hydrological function of Te Whare Whare. It simply wouldn't be applying for consent to do that. Yeah. Yeah.
That makes sense.
Yeah. Right, so if I turn now to paragraph 20, matters raised in submission. So what I've sought to do here, because of the comprehensive planning brief of Mr. Lowe, is not sort of go over things that he's already addressed, but rather flag matters that I thought might be of interest or relevance to the panel from a legal perspective. So I've set out A to H, that I'll look at amendments to the application requirements for consent and activity status, permitted baseline, the RM reforms, the applicability of the policy statements, briefly legal tests, some differences across expert evidence, and some other specific legal matters arising. I don't plan to read the next 20 pages to you. I'm going to talk really high level, and I'm happy to then go into more detail as you need it, but the legal reasoning is being set out in the document. So the first one, in terms of amendments to the application, I've just stated the law, which you'll know that you can make changes up until the close of the hearing, provided they're within scope. And just confirming that the amendments that have been made seek to minimise that risk of potential effect and are within scope. In terms of the application requirements for the consent and activity status, you will have seen in the officer's report and across the applicant's evidence that there was a disagreement as to whether the activity was non-complying. That disagreement related to whether there was non-mining buildings not meeting the standard in the Westland District Plan, and it effectively hung on the interpretation of what mining was and whether that wet concentration plant was part of that mining activity. I've set out our position in legal submissions, but I received a call on Friday night from legal counsel for Westland District Council, who has confirmed that on the basis that we've now in a lot of detail explained that process in the evidence, that the reporting officer is comfortable with our activity status being discretionary. So there is now agreement, as I understand it, across the planners that we aren't looking at a non-complying activity. If you're interested, I've set out from paragraph 20.
Discretionary.
No, there'll be a few other consents required that will trigger it up to discretionary. But the mining activity itself will be restricted discretionary, correct?
And am I right? In preparation for this, I was looking at the Westland District Plan. Is it that quite small document? Is it quite a small document?
I don't know if you'd call 200 and something pages small, but yes, it is. It is a small document. It's very permissive. It was, obviously done some years ago and reflected the very permissive nature of mining in rural areas for Westland District.
So it is that document.
It is that document. Yeah. There is, as you'll be aware from other processes now, a proposed combined plan where Grey, Westland and Buller are doing the proposed Taipatini plan. That I'm involved in is still in the hearings process, and there's some dispute on legal effective rules, which I'll turn up to shortly. But I think instead of us going through that, I've put links as to the legal opinions that were provided, and I've put a position in terms of the activity status. But I now understand, and the consultant planner is nodding, that that's sort of off the table now that we've actually explained why the plant isn't processing. It's simply similar to alluvial gold mining. It's taking the material, extracting it and putting it back. And Mr. Chase talks about how, you could have that plant following the dredge, but we looked at that up front and thought that that wasn't a very good amenity outcome. So it's been placed in a way that's a way.
Yeah, I mean, I had the benefit of other applications for sand mining, and with the benefit of that knowledge, I didn't understand the previous opinion.
Yes, and I make that note at 29, where I say our view is the contention that it's not part reflects a misunderstanding as to the role of the plant, but that Ms. McGrath now accepts that it's part of the mining activity, having read the applicant's evidence explaining that process more fully for her. So I think we're all on the same page now, which is useful.
Yep.
Yeah. So on that basis too, I haven't gone through non-complying activity tests as a precaution.
Yeah, I was struggling to see how that could be right.
Correct. And to be fair, my involvement on different consents being granted under this council to date, it's never been an issue. It's always been an activity. So it's the first time I'd encountered that as a problem. And this is
right. You would be any of the gold mining.
Well, there would be a bunch of non-complying activities right across the district, right?
So you'd have to have tailings dams in the industrial area, because they're no less or more processing than taking out by gravity mechanisms.
Correct. I should say, because I've been involved in other matters, the background to this came from a delegations authority, which was a register, which was prepared some years after the district plan, which has a comment in it that it excludes buildings from the delegation to the West Coast Regional Council. So to date, and in other hearings that you've been involved in, the West Coast Regional Council has delegation for mining activities. So they cover the consents of both the district and the regional council. And it appears that some keen eye has spotted that the excluding of buildings now means that Westland District Council should be processing building element. And I think that's where the confusions come from, is from the delegations register. And my first set of legal submissions sort of talked through that and explained that, obviously, as you'll be aware, that's not a measure for interpreting a district plan that was prepared before a delegations register. But I think that might be where the sort of confusion has come from. But we're all on the same page now, and I'm happy that that's one less issue for you guys to think about.
Yeah, oh, well, it wouldn't have been too hard, but we're
Yeah.
not going down that rabbit hole now.
Yeah. So the next sort of planning disagreement was under the TTPP, where Mrs. McGrath, is it Mrs. McGrath or Grath? Grath, sorry.
Doesn't matter.
Thank you. Ms. McGrath has identified that SASM R7 as a rule with immediate legal effect. We just simply don't agree with that. And when you look at the Taipatini plan, which I'm very engaged in, it is a Pounamu overlay. It is not a site of significance. The sites of significance under the TTPP for this area is just the creek and the Lake Mahanapua. So we don't agree that that rule's triggered, but in any event, we don't think it makes much material difference whether it is or not. You may be aware that this came up under the Barrytown decision as well, and it was confirmed that it didn't have legal effect in that case.
But how can there be debate about whether something has legal effect? It either does or doesn't. How does the debate arise?
The debate arises as to whether you consider a Pounamu overlay area, which has come as a result of the Vesting Act, the Pounamu Vesting Act, is a matter of historic heritage, I think, are the ones that trigger legal effect. I think what the Taipatini plan does is actually lists those rules which have immediate legal effect, and this rule isn't listed, and the sites of significance to Māori are listed. So,
well, it's probably, I suppose, arises because of definitions of historic heritage are so expensive they couldn't include anything.
it could include anything.
And the idea is because Pounamu are precious, or taonga, it's historic heritage, but I think that's a stretch, isn't it?
Well, that's not the position of the council, and it's not the position of the applicant, but that is an indication in the officer's report. Yeah. Yeah, so I would agree that that's our position, is we just simply doesn't think it applies, and that's the council's position who's running that plan as well. Yeah. And we've also just confirmed there that we don't consider a consent required under the natural character provisions relating to riparian margins. And that is that this activity is set back greater than those distances in any event. Yeah. We've talked about regulation 45D. And if I can turn now to paragraph 36, which is the permitted baseline. So while the technical assessments prepared for the applicant do not rely on the permitted baseline, we are specifically instructed the technical people not to look at that. The RMA does provide the panel with the discretion to disregard any adverse effects of the application arising from the permitted baseline, being an activity with the relevant effect that is permitted in a national environmental standard or a plan. So the permitted baseline had its origins in case law, where the Court of Appeal created a mandatory rule that if permitted non-fanciful activities on a subject site would have an adverse effect, then consideration of a resource consent application should consider only the incremental adverse effects the application would have over and above those of the permitted activity. The reasoning for the permitted baseline is that if a relevant plan made an activity permitted, it represented a community view that the effects of that permitted activity were acceptable, and therefore a proposed activity should be able to take those effects as acceptable on that site. It was codified in section 104.2 of the RMA, but with a discretion to apply it, which recognised concerns that had been expressed in case law that it was not necessarily appropriate to disregard the effects of the permitted activities at all times. So Mr. Lowe considers it's appropriate to apply a permitted baseline from which to assess the effects of the proposal. My submission, I agree with that approach, and the Westland District Council reporting officer does not apply a permitted baseline or think it is particularly determinative for the consideration of this application. There is no requirement that a permitted activity be of the same type as the proposed activity in order to apply the permitted baseline. It calls for a comparison of effects. And Mr. Lowe sets out some of the relevant effects that the district plan, in particular, the Westland District Plan, anticipates for permitted activities, such as no control on noise effects for forestry and agricultural activities in the rural zone, no control on traffic road noise, large-scale buildings with no limit on colours, permitted forestry, shelter belts, planting, farming without fencing any forest fragments in the mining area or adjacent eastern escarpment area, and permitted removal of areas of vegetation, including the forest fragments, permitted earthworks such as humping and hollowing, 5 hectares per year, which could be across 80 hectares over the term of the consent. No setbacks apply for earthwork activities from scheduled wetlands such as Tūwharewhare or Mananui, and there's also significant earthworks that are permitted. So these provisions paint a picture of enabling a working environment in the limited areas of productive zones on the West Coast. They can't be said to be out of date in my submission, given the age of the district plan either. It's an approach which is consistent with the West Coast Regional Policy Statement, a second generation statement made operative on 24th of July in 2020, that identifies that the West Coast is rich in its level of remaining Indigenous biodiversity, having 84% of its land under the control of the Department of Conservation. So in a national context, this is a quarter of all protected land in New Zealand, and it does reflect the reality that there is very limited land available for productive uses in the West Coast. So the regional policy statement also specifically recognises the role of resource use and development and mineral extraction specifically, and its contribution to enabling people and communities to provide for their social, economic and cultural wellbeing. It actually is interesting in that it seeks to protect mineral resources so that they can't be sanitised or not being able to be extracted. So it's the only plan I've ever seen do that. It also seeks to protect the significant Indigenous vegetation and habitats of Indigenous fauna, but on the same level, in that same objective, it also seeks to provide for the sustainable use and development and enable people and communities to maintain and enhance their economic, social and cultural wellbeing in areas of significant Indigenous vegetation and habitats. It seeks to protect the natural character of the region's wetlands, lakes and rivers from inappropriate use, but it also seeks to enable people and communities to maintain or enhance their economic, social and cultural wellbeing. Activities which have no more than minor adverse effects on natural character are explicitly stated in policy as being allowed. And it seeks to protect the region's outstanding natural features and outstanding natural landscapes from inappropriate development, while allowing the use on, in and adjacent to outstanding natural features and landscapes to enable communities to enhance their wellbeing. So activities in outstanding natural features and landscapes that have no more than minor effects are also explicitly allowed by policy. Now, I'm not saying that they have to be applied in all circumstances, but what I'm trying to paint here is a very different picture to what you might see in some districts, in terms of there is a recognition of the abundance of these really special and protected areas across the West Coast, but there's also a recognition in the same breath that the community needs to be able to enable its social and economic development. And so what we're trying to achieve is a balance where both of those can occur, and that has been the focus of this application as well. And interestingly, you'll see in terms of the RMA reforms, a sort of a swing back towards that approach where, you know, with the NPS Indigenous biodiversity and the NPS freshwater, where there have been consenting pathways now for important infrastructure, mining activities and the like, provided they apply an effects management hierarchy and ultimately have appropriate effects. So if there's no questions on that, I'll jump to resource management reforms.
So you encourage us to read aspects of the RPS to just see how that is the most, you say that's the most contemporary regional statement of the issues and how they want it, we want.
I guess I'm addressing the criticism that the Westland District Plan is very permissive, but it might be old thinking. Because the reality is when you line that up with the recent thinking of the RPS, the same approach is taken. So yes, I would encourage it. There is a strong economic focus in the RPS as well as a strong environmental protection. Yeah.
And just a question there. And has the RPS, has that given effect to the latest national directions, such as the National Policy Statement for?
So it's included the compulsory sort of pick up and drop in policies, but it hasn't been reconsidered, for example, because it's so recent. It wouldn't have been reconsidered. You'll find, and I'll address later in submissions, for example, that approach is taken in, say, the MPSIB, which has the effects mitigation hierarchy, is actually currently in the RPS already there and more encompassing. So in terms of Indigenous biodiversity, the RPS creates more areas to be considered under the effects mitigation hierarchy than the MPSIB does. So it already has, it's very much aligned to a lot of the national policy thinking, and in some ways goes further. Yeah.
I do have a question about paragraphs 37 to 40 or 39. And it's more out of interest because I haven't thought about this question for a while, but when the permitted baseline was first established by those Court of Appeal authorities, there was a famous decision in Christchurch from Judge Bollard, now deceased, about, and it was about the court trying to struggle with this new idea that essentially hadn't been around before then, which was about the idea of excluding the effects that are other or further than the baseline, as distinct from how you evaluate the effects of the activity through the lens of what the policy generally enables. And I'll make that distinction this way. So in that case, the judge said, well, if I'm going to do this task of excluding effects, I need to have something tangible to say this is a baseline from which I will now exclude effects. And that was quite a difficult standard. I'm not sure whether it's still being applied, but yours is a slightly different approach, which is saying generally this is a working environment through which a number of things might happen. We're not going to give you an example of a dairy farm with all of these features in it and say, here's a baseline from which you then measure our effects. So our MSC or the plant that's there is only 10 metres taller than the largest barn. You're not asking us to do that.
No.
And I wondered whether what Mr. Lowe was really saying was not permitted baseline in the sense that the statutory direction is ignore effects that are permitted, but more something akin to say, look, in the real world, these plans permit a range of productive activities that can, in various ways, produce these outcomes. And you need to recognise that the thrust of that is a recognition of a working environment of which this is not atypical either. So it's more in the sense of the policy, Section 104(1)(b), how the lens of viewing the policy in which to interpret the effects, as opposed to an effects calculation. Does that make sense?
That all makes sense, and I think it's both. So the way Mr. Lowe and I have discussed it and considered it is there's a couple of things at play here. We've got Mr. Robertson, who's a landscape architect for the Westland District Council, who has assessed effects with no consideration at all to what you're talking about, which is the working environment and the context. So in my submission, and exactly what you've just explained, it is very difficult to understand what an effect on that land may be with assessing that effect in a vacuum, essentially. You must have a look at the context, and quite often that is, as a minimum, the underlying zone of which that applies. So if this was an open space zone, the way you were to interpret that effect would be very different to, as is the case here, which is a rural zone, which explicitly provides for mining, farming, forestry. So that I agree with, and that's what you're explaining, and I think absolutely that's not the permitted baseline. For me, that has been recognised in case law as being relevant to your assessment under Section 1A, actual and potential effects, by also looking at B as part of A, because you need to understand the provisions and plans to be able to make an accurate and what you say, real world view of what an effects of an activity might be.
Yeah,
So I think, yes, you're correct. That is what Mr. Lowe says. I think we go one step further to say it's appropriate to consider the permitted baseline on the site because of where we get to by Mr. Robinson suggesting mitigation measures that should be implemented. For example, one concern that stood out from Mr. Robinson was he is concerned as a driver or a passerby on State Highway 6. He's concerned that as they turn, that if there is a bund protecting there, that they're going to lose a fleeting view to the Alps as they drive past the site quickly. And the suggestion of the permitted baseline there is, well, the reality, and you look at the farms further down the road, is that there could be a permitted shout-about right along that boundary, and the passerbyers aren't going to have that view of the mountain anyway.
right.
So there are two elements at play, and I think you're right. That's exactly what Mr. Lowe is saying in terms of context, and we're concerned that the district council reporting planner has not considered the context of the plans, and we're concerned that Mr. Robertson is also assessed in a vacuum. But when you get to actual mitigation and suggestions of mitigation, I think the permitted baseline does become relevant in terms of, you know, we know from case law there's no right to review, but we also know, looking at farms around the area, that things that block views to a site are also the normal of farming operations, and that would be an application of a permitted baseline when considering mitigation.
Right. So you're saying primarily the first, which is what I said, but
Correct.
in individual examples like view shafts, actually the old traditional permitted baseline should be applied because you could imagine a non-fanciful activity where that
Correct.
is subtracted.
And that's really why we focus so much on it, because of the strong recommendations of different mitigation. And I'll come to it shortly, but the concern from the applicant is they have engaged very heavily with the community on this proposal. They have gone and spoken to the neighbours. They have shown their plans, which include a focus on the residential amenity of people who are close to the site. And the recommendations from Mr. Robertson are more from a landscape effects, broader picture, someone passing by the site. And the concern from the applicant is that there are only 2 submitters who have, from that immediate neighbourhood, have made submissions. And the rest of them have obviously been happy with where we've got to on the project, and they haven't chosen to make a submission. And so that's why we're leaning on the permitted baseline at that point to say, look, while we understand your reasons for wanting to open the site up and people to have views of the mountain, we do need to look at the reality of, well, one, the background to this environment, which is there's been heavy consideration of this by neighbours. But the second one is the reality that all of these views could be gone tomorrow if we planted a shout-about, and the passing-bys wouldn't be able to see this stuff anyway. Yeah.
I'm struggling to land that in my mind without having seen the site. That's
Okay.
what views you're talking about, but I get the point.
Yeah.
Just one thing that arises from that. I suppose it's less of an issue now with the mining question put to one side, but as I understand it, mining is an RD.
Correct.
Under the current law, does the bundling principle still trump the statutory direction not to have regard to matters outside the limited discretion?
Oh, that's a good question. I think in this case, it's not an issue for this hearing, because if you run your eyes over the list of discretion under that RD mining activity, it is all encompassing. I can't think of an issue that's not under there.
It's on landscape, because when I look at the RDs for landscape, essentially they focus primarily on effects on an Owen Fell.
They do, correct. I remember that.
And then there's this RD amenity. Now, I don't know what amenity would mean in this context, but the question is, in my mind, is this are we to decide the amenity of the rural area properly conceptualized as to a productive environment, or the amenity from a person who is viewing the rural land? In other words, is amenity something which is just simply amorphous and sits there in the existing environment as something that people can claim or enjoy, or does the zoning patchwork, in a sense, fundamentally affect the lens of amenity? Because you can't say if I'm sitting across the road from a park in my residence and it's a reserve, in a sense I can appropriate an amenity from that because of the nature of the zoning.
Correct.
But the reverse is also true.
Yeah.
And so my question is there some ring fencing to be put around the amenity concept in the RD list?
So I think the approach that
may take some time.
Yeah, we'll have a think about it. The approach we've taken in the application is not to restrict consideration of matters and to bundle the discretionary and restricted discretionary so that all matters can be considered. We haven't tried to separate or ring fence it, and I can consider whether that's appropriate. But what you're talking about is what Mr. Lowe is addressing in terms of planning, in that it's very difficult to take just the landscape provisions, as has Mr. Robertson done, and to filter them down to the site without considering that the objectives regarding the landscape give effect to the policies, which give effect to the zones. And so through that traditional hierarchy of rules give effect to policies, give effect to objectives, you can see when you read that plan that there are areas set aside for significant protection that do have what Mr. Robertson's referring to, which is views from the mountain to the coast. And you can see that south of the site. But, you know, the position of our planner is that that doesn't apply to the site for a bunch of reasons. And I think Ms. Crawford makes those same comments. But we'll have a look at that amenity in particular, because the amenity in the district plan provisions around rural activities is very much focused on the people who live and work in that rural environment.
That's their amenity, that's their coherence.
Yeah.
And the reason I say that is that whatever one says about the bundling principle, it can't justify losing sight
Of the local
of the plan provisions.
I agree.
So
Yeah.
if the plan says RD and these are the things that we're concerned about,
Yeah.
and then you use the bundling principle, so I can completely ignore that and have a blank canvas of no planning.
Correct. Well, you
run the risk of actually undermining the very purpose of the planning document, and I can't see how that's authorised.
That's correct. And Mr. Lowe has the same view, Commissioner. I think the reality here is this plan, when you read it in totality, as opposed to just one section, like the landscape section, is very clear on how it wants to see things end up on the site.
Yeah.
And we, you know, I guess the criticism or concern is that the experts who have assessed it on behalf of the council have only looked at their isolated sections as opposed to looking at the contextual relevance.
Yeah.
But I've made, and I can see Mr. Lowe writing some notes too, so we can come back and address those matters.
It's just about, I think one has to have respect for the planning framework.
And that's what I'll make. I won't need to make it now. Later in these submissions, I make that point that you can't assess effects in a vacuum. The plan context is incredibly important. I make that 2 or 3 times later on, because I think that's what we've lost in terms of the difference in opinions. Yeah. So the resource management reforms can be talked about, you know, touched upon very briefly. The first one is well known. It's the Freshwater and Other Matters Amendment Bill, which actually now requires no consideration to essentially that hierarchy of importance. While that is the reality of the Act, it's not something that we think is relevant to this case because of the importance, the cultural importance of Te Whare, and we say that whether or not these matters can be considered by the panel is little relevance because what this project has been done is designed to avoid hydrological impact on Te Whare and the Mananui wetlands. And I've talked about the things that we've done to make sure that happens. In terms of the stock exclusion regulations, we're talking about 41 subparagraph C. Yes, there is stock exclusion regulations. Yes, they apply to scheduled wetlands, but they don't apply to any of the vegetation areas within the application site or what we call the escarpment area, which is the vegetation edge between the mining area and the wetland. So stock can still freely roam without a requirement to fence it. The Amendment Act has also proposed changes to the MPSIB around SNAs. They're not relevant to this application. I've also noted just briefly the wildlife permits. That's obviously a separate process, but has come up in submissions. And the coalition government has signalled a raft of other changes to the RMA, including a huge amount of documents that arrived last week on National Policy Statement and just confirming they're not enforced and are not applicable to this application. So the next bit I think I can touch upon quite briefly from paragraph 44. I've talked about how there's agreement between planners as to what's relevant in terms of the instruments, and then there are some legal points relating to the MPS freshwater and the MPS Indigenous biodiversity. So one is that consideration of Te Mana OTY for resource consents, and the other one is the applicability of the MPS IB, natural significant area. So without reading this, which might bore the team in the background senseless, I think the key points to take from the MPSIB is the policies that are relevant to the site are the ones in relation to the SNA. The SNA is defined in the MPSIB. It essentially requires you or the councils to have on commencement of that MPSIB to have been mapped in a policy statement or a plan. So the Westland District Plan doesn't have anything mapped, neither does the TTPP for Westland District Council. So the only thing that's mapped or identified clearly is the Schedule 1 and 2 wetlands, which are in the Land and Water Plan and which has come through recently. So in terms of the applicability of the MPSIB, and then therefore the application of the effects mitigation hierarchy, the only thing it applies to on the site is the areas that have been scheduled wetlands, which are mapped in terms of, it'll be attached to the conditions. So the map at tab 18.
So can I summarise this this way?
Yep.
We're not dealing with the MPSIB in relation to the disputed remnant forest.
Correct, that's applicant's position.
But we are,
Or the eastern escarpment.
well, the eastern escarpment doesn't apply because you're not in it. You're not going into it.
No, but the MPSIB has quite clear policy direction that even if you're not in an SNA, but you're outside it, or Indigenous biodiversity may be outside it, you also have to apply the effects mitigation hierarchy.
Right.
Yeah.
So that, but in relation to the removal of the residual remnant forest,
They're not mapped and they're not.
it requires a consent from the Westland District Council because it triggers a rule. Is that correct?
Yes.
Or is it just that it is mining?
It's mining.
And one of the questions is the effects on significant natural vegetation or something. Is where what's the
trigger?
the IV is off. What is the rule that guides our policy?
So it becomes relevant if it's an SNA. And the way you could be assessed as an SNA in terms of the fragments in the land is by being assessed under the MPSIB, which you're off, is being assessed under the RPS criteria, which is not the case here, although there may be disagreement with that by the council ecologists, or being assessed under the TTPP criteria, which again is off here. Otherwise, the district plan has a permitted vegetation removal that you could remove some of that area, over time remove more of it, or you are part of the mining considerations which come back down to your effects on SNAs.
I'm not sure you've answered my question though. What is isn't there a rule I've seen that governs removing Indigenous vegetation? Is there a rule that is triggered here?
A discretionary, are you, you're saying?
Discretionary activity.
Yeah,
So that applies because it is Indigenous vegetation,
correct, over a certain level. I think it's 5,000 metres squared.
right?
Yeah.
So significance is another question. And
Yeah.
when did that rule come into effect?
That's part of the plan.
The Westland plan?
Yeah.
So that plan then talks about some things in the significant adverse effects on significant natural vegetation and so forth. When it's making that assessment, isn't it really referring to ecological practice is what you would assess as significant?
Correct.
Rather than kind of thought about the regional plan because it was well in advance of that. Kind of thought about the MPSIB because it was an older plan.
Yeah.
So it must have just had a sense of that ecologists would assess significance according to the practice of ecology. And then people have in this evidence borrowed from other instruments the assessment of significance. And what the ecologists' differences of opinion seem to demonstrate to me is that whatever terminology you use, it still comes down to a matter of assessment.
Correct.
And I guess I feel like Donald Duck with my eyes going round when I refer to all of these different definitions.
That's right. There's a lot.
I'm not as bright as the ecologists, and I
think their eyes go round too, to be fair.
And so to signal this, I'm not really interested in, first of all, from my own personal view, I think the MPSIB is structured as a document that is intended to go through a structured, transparent process of assessment of the region's resources and then identify them and so forth. And that's above my pay grade, which is, I'm not doing a plan exercise here. And I wouldn't presume to do so because I wouldn't like it if I was in the shoes of the landowner.
I absolutely agree. I think
so, but I am interested in just a common sense ecological view of the assessment of significance using the well-known guidelines.
They've assessed them under every different instrument for you. So
but that's what I'm interested in.
Yeah.
And what I'm interested in is the distinction between that which is factual and that which is evaluative based. And when I say evaluative, I mean a judgment
based. Yeah.
Because we've got an unhappy position of ecologists saying your transects are the wrong transects, or there are not enough of them, and what I'm prepared to get my hands dirty about that. But the question really is, explain to us, if you're an ecologist and a professional and you're working off these guidelines, what do you do and how do you establish that significance based on the 5 criteria? And what is factual and what is judgment? And one point, I'm sort of declaring my hand a little bit because I want to signal this because it's a big topic, an important one. It seems to me that the IB demands a transparent process because you have to have a sense of the region's resources generally. in fact, to make that judgment, some of those judgments. So,
You're absolutely correct, because if someone like Dr. Keesing identifies a significant natural area through a resource consent process, there's an explicit requirement that that information then needs to be assessed by the council as to whether or not it is included.
yeah,
Because it requires that oversight of the
correct.
region.
It's a completely different lens. So I think there is a line of fallacy thinking here that even if we did reach the view it was significant on an ecological assessment, that would preclude or somehow influence, because it might be that in a binary we get over this hump, still a low level, significant. The rule doesn't mind. It doesn't.
No, that's
it's
right.
Completely agnostic about that.
Correct.
But what I want to get to is some sense of why they're different, why they have different views, leaving to one side all the baggage of the IB and all of that. So that's what I would like to, because I haven't seen this area myself, but reading the ecology evidence, I'm intrigued that two experts reach one view and another expert. So that it could be factual context difference or it could be judgment.
If I may suggest as well, it is really quite useful to actually go and look in the Dock Reserve too, next door, in terms of the contrasts between the site and the reserve, just to understand what you're looking at and what it could have looked like, sort of thing.
And what I want to also, that reminded me, what I wanted to understand from the ecologists is, I'm confused by the concept of context, but it's apparent that there are permitted activities, including stock and all of that. Whether significance is assessed in a static photographic image sense of the situation now, or whether ecologists to some extent draw on the fact that, you know, we'll look at when you look at its stability or its enduring nature, look what's happened in the last 20 years or 30 years, and what could happen. How much of that actually influences an assessment is a matter of interest to me too. Sorry, that was long.
There's no answer to that question from me either. I think all I'd say from a legal perspective, which you'll be well aware of, is once you get to the bottom of whether or not it is significant, it does require specific assessment for resource consents under the NBSIB. And that is that if you are deemed a significant natural area, then you must apply the effects mitigation hierarchy. So that is a legal requirement. So the outcome of whether or not those forest fragments are important is relevant to the sense of the effects mitigation hierarchy. From a legal perspective, the forest fragments and the escarpment don't trigger the NPSIB. So it's not under the NPSIB that you're looking at the effects mitigation hierarchy. There's also an assessment required under the RPS as to whether something's significant. And if you meet that significance requirement, you're required to follow a very similar approach to what is put in the NPSIB, which requires you to avoid in certain circumstances. And then if you can avoid, you have to then do the avoid, mitigate instead of minimise, remedy, biodiversity offsetting, biodiversity compensation. So I guess the relevance from a decision maker's perspective, in my view, is that once the ecologists, you know, you've worked through and decided as a panel whether or not that's significant based on the ecologist's opinion, it then requires, under different instruments, individual resource consent assessment against effects management hierarchy. As I'll go on to say, is at the end of the day, this application has taken that restrictive approach regardless, because of the sort of I guess, different instruments coming over at different times, it hasn't sought to distinguish, hey, look, we're going past the eastern escarpment, so we only have to mitigate, not minimise, or hey, look, there's the wetland over there, values might be impacted, so in this instance, we have to apply. It has taken that more restrictive approach because...
Are you I don't think what forces us in relation to remnant forest to apply the effects hierarchy? What's the instrument that forces us?
So it would be the RPS.
The RPS does.
Yeah. Yeah. So under the Indigenous Biodiversity chapter, there is a requirement to protect significant effects on significant natural areas by applying, similar to the NPSIB, where it's got that avoid certain types of effects on ecosystem representation, and then you go into avoid in the first instance, mitigate, not minimise, then remedy, then offsetting. So I've actually set out to assist at paragraph 58 in terms of when you get to an assessment of the effects mitigation hierarchy. So if we were to take a helicopter view of the site, from the applicant's perspective, Dr. Keesing, supported by Dr. Bramley, have identified 2 natural inland wetlands. So that's your Whari and Mananui, and then there is a perched wetland on the southern boundary in the Dock Reserve. Okay, so when you look at that from an NPS freshwater perspective, noting you're not triggering a consent requirement, but you're looking at it from a policy perspective, when you look at that, you have to apply an effects mitigation hierarchy to any adverse effect on values. So from a decision maker's perspective, you'd be looking at whether there was an adverse effect on a value, and if there is, that creates the requirement to have an effects mitigation hierarchy, which is avoid, minimise, remedy, offset, compensation. So that's from the NPS freshwater. If you look at the NPS biodiversity, ironically, it's a terrestrial ecology biodiversity statement, but the way the RPS has been set up is that it identifies wetlands as an NPS, as a significant natural area. So as a result of that, it imports a requirement for the Whari lake and wetland area to also have the NPS IB effects management hierarchy applied to it if there are obviously adverse effects, which have sought to be avoided here. So you've got those ones that apply, and then you've got the RPS, which actually takes an even broader approach than the national policy documents, where it just talks about Indigenous biodiversity, and that could capture the reserve, the escarpment, and depending on your outcome of your assessment as a panel between the different views of the ecologists, it could or could not capture the forest fragments. Now that requires an effects mitigation hierarchy, which is avoid, mitigate, remedy, offset, compensate. Do you see that cluster that we've got, what we're working with? From the applicant's perspective, it has sought to avoid effects on all of those areas by avoiding them, and then sought to minimise, and then sought to remedy, and hasn't moved to offsetting or compensation.
But that seems, I understand that, but in relation to the remnant forest, removing it is not avoidance. So you're saying it's not significant.
Correct. We're saying that none of that's triggered for the remnant forests.
Yeah.
Because of the views of the ecologists, which were internally peer reviewed as a sort of a risk strategy for the applicant to understand. So they've had Dr. Bramley consider Dr. Keesing's opinions and also provide evidence. So moving to paragraph 58, which I've just kind of done that quite briefly for you. I also have just set out, because it's sort of a new area of law, we thought the panel might be interested in how this has been applied or assessed in other recent cases. So at paragraph 60, I just say, look, a common mistake approach to the effects management hierarchy recognised recently by the Environment Court is to argue that avoidance is always possible if one abandons the use or the activity sought. And the court said this fails to grasp the point of such a hierarchy, which is to direct the applicant to first and foremost seek to avoid the effect in question, not the activity or use applied for. So I'm just highlighting that. And
This one.
that was the Friends of Conical Hill, Huranui, Judge Semple, just recently, where they're putting a gondola in, and there was construction required in areas that had significant lizard habitat.
Right.
So then from paragraph 61, I just acknowledge that there's a difference in opinion between Dr. Keesing and Mr. Payne as to whether we're talking about remediation or an offset. And I've set through just the law, which I'll just talk to briefly. So in terms of a void, I feel like you'll all be across this, been in the Barry Town, but a void has been found by the case law to be a void material harm. And so I've just acknowledged that at A. So if we're talking about minor or transitory effects, that can still meet the definition of a void, depending on the context in which it's applied. In terms of minimise, the MPS Freshwater and MPS IB have explicitly included this term minimise, and it differs to what we traditionally have known as mitigate. And I've said that the only case that's referred to that is the Friends of Conical Hill, which I've just referred to earlier, where in that case the court was satisfied on the basis of expert agreement that applying plantation forestry best practice measures for the presence of birds' nests aligned to DOC practice would be sufficient to minimise. So the usual word or meaning of the word minimise suggests, in my submission, a reduction in that adverse effect. And then in terms of remedy, I'm not actually aware of any case law where the courts have directly commented on what constitutes remedying, as parties are often agreed to what constitutes remediation. So this was the case in the Royal Forest and Bird Protection Society and the West Coast Regional Council, which is a local case, or known as Te Kuha, and where the experts for the Department of Conservation and the applicant were agreed that remediation includes vegetation, direct transfer, habitat creation, weed control and rehabilitation. There's also another case that I've referred to where there's a dispute as to whether measures offered were a remediation measure or an offset, but the Environment Court declined to make a finding on that point, given it had already found that the effects were less than minor and the parties were agreed that the measures would have a gain. And the only other case I've referred to in terms of offsetting is the recent case of Meridian Energy and Tararua District Council, which was the Mount Munro wind farm case for Meridian. And in that case, the applicant offered a 1-to-1 ratio offset as being appropriate given very low value of the wetlands. And the Environment Court stated that small areas of low ecological value wetlands totaling no more than 0.35 hectares will be directly impacted by the project. The loss of these areas is to be offset by the establishment of at least the same area of wetlands within the project site. This is likely to be of higher ecological value, and the approach is appropriate in addressing the adverse effects on wetlands unavoidably lost through site construction. So I think in terms of that hierarchy, there is a bit of a blurring between if you're a remediation or an offset, and you may have seen across the evidence for the council and the applicant's evidence, it seems that Mr. Payne is suggesting that an offset and Dr. Keesing is suggesting remediation. What those cases demonstrate is that largely between that remediation and offset, you've got the same outcome anyway, you know, the 1-to-1 value if it's of low value or, so I've set it there for reference if that becomes an issue that I can address you in reply. But I think
I end up being like Donald Duck again when I get to the distinction between remediation.
Correct.
And offset. But isn't it the practical question? What are we getting at the end of the project relative to what we've
the values are correct.
And that's not purely a numerical exercise. I mean, I know that there are methodologies in freshwater for calculating offsets.
Correct.
But the major difference between the experts here appears to be the temporal loss of the vegetation in the remnant forest for the time it takes for the mature
to
vegetation to recover, that there are no other losses, leaving to one side the hepto-fauna debate.
Yeah, and well, it's whether the mitigation of relocation, if any, is effective.
Yeah.
In terms of if there is any hepto-fauna there.
So you get an incommensurate comparison between a larger area with better wetlands adjacent to the escarpment, which is arguably a superior ecological location, against a time loss. Those are two.
Correct, and essentially.
And I wouldn't have thought that lend itself to a particularly easy ecological calculation, because absent threatened and at-risk species, which are temporarily lost their home, which is a significant ecological effect, it's simply a change.
Correct, and that's essentially, I think, where the courts have got into when they're applying this effects mitigation hierarchy. And the last two cases I've referred to haven't made a decision on that. They're just simply looking at what the gain or the values are. I think as we're all aware, practicing under these new policy statements, I think it can be a bit prescriptive and contrary or a bit clunky to apply, but I'd agree that's exactly what you're looking at is the values.
Well, if you treat policy as like rules, you end up making them.
Yeah. Which is why we've seen an approach to moving the broad balancing again, even of directive policies by some of the higher judgments. So I am worried that I'm going to run out of time, and Mr. Hardy's giving me the look because he'd like to prepare before lunch. In terms of what I've set out next, I very briefly set out legal tests acknowledging that this framework is well known to the panel with two planners and a lawyer on it. And so you know which sections we're applying. In terms of the planning provisions, I've just acknowledged, and we've already discussed this, that context is particularly relevant in this case in terms of the applicability of the district plans. And it's acknowledged that some more specific or directive provisions may warrant greater weight, but you've got to consider them comprehensively and appropriately reconcile them as you can. The panel can be confident that a thorough assessment to assessing the potential effects of the application has been undertaken. And I say there that once the effects are balanced with the significant positive effects of the proposal, the short-term nature of the activity is considered, it's clear that we meet the sustainable management purpose. I just want to touch briefly upon some of the submissions that have raised inadequate information as a reason to decline under section 1046. The Environment Court has stated that discretion should be exercised reasonably and proportionately in the circumstances of the case. A number of submitters and the Westland District Council have raised the issue of inadequate information, particularly with regard to ecological matters. In our submission, the application provides a comprehensive assessment of relevant effects, noting in particular that further assessment has been undertaken in terms of the assessing wetlands and the significance of the forest fragments and noise effects. And I just want to say there that differences in expert opinion do not equate to inadequate information.
Where is the reference to that?
Paragraph 66. And I've just acknowledged there at 67 that the reporting officer for the Westland District Councils considers the application should be declined, but the officer records that she can see a pathway subject to a satisfactory response of further information being provided. She helpfully set that out in Appendix 1 to that report, and this has been addressed as appropriate in the evidence of the experts.
The gridded air case, which I had experience in, was principally based on insufficient information. But the test is has to be reasonable and proportionate. Isn't it the case that an applicant for a hearing can reasonably expect they have provided the information sufficient to determine the application, because that's the whole point of Part 5?
Yes.
And so under 106.47,
you have to consider whether the council has requested that as part of it.
and there's been no refusal of information.
Correct.
So if we thought that there was a need for further information, the first thing we'd do is ask for some information about it or evidence,
Correct. Yeah.
but not say, oh, we can't determine the application.
Yes, and there's some case law in the High Court. I haven't read the Grenadier case recently, but there's some case law in the High Court which essentially says that this is something that the council does as a first gateway in terms of ensuring there's enough information to proceed to hearing and that it's part of an iterative process. One thing I'd note, though, that there is a suggestion in some of the submissions that because Mr. Payne has a different view to, say, Dr. Keesing, that the applicant hasn't provided enough information. And that's something that I would say that I disagree with. I think experts are entitled to have different opinions on information, and that doesn't make it inadequate, is the point that I was trying to make there.
I'll be interested to know those cases about the iterative process.
Yeah, there were two High Court cases. I'll dig them up for you. One of them takes a different view to the other one, and they've both been cited.
Yeah.
Since, depending on which suits each case.
Yeah.
Conditions of consent. The point that, section 105 and 107 at paragraph 68. The point I'm just making there is those matters have been addressed through the evidence. They're obviously sections that you're required to consider as part of this application. And the condition of consent section at paragraph 70, obviously your finding of effects is directly relevant to the imposition of conditions. So conditions can only be directly connected to an adverse effect unless the applicant agrees to them. And just a note in terms of pro-offered conditions, recently the Environment Court has cautioned against replicating conditions of consent from other proposals in the same industry, as this may create a de facto industry standard. This was in the context of proposals for monitoring of species, where evidence supported a conclusion that there are no population scale effects. And the reason I have raised that is because there have been other consented sand mines in the region. There does tend to be a tendency, for example, in the peer reviewing noise evidence and the officer's report of picking up conditions that may not be relevant, for example, on sight lines, on roads and things like that. So I'm just urging you to exercise caution of bringing in conditions when they haven't been thoroughly considered in the circumstances of this case. At paragraph 74, and I'm nearly there, everyone who's starting to look sleepy in the back of the room, I have just really lightly touched upon the material difference across the technical expert evidence. It sounds like the panel's across it from the questions being asked at the moment anyway. We've obviously got the difference in opinions between the ecologists, and I've set them out. There are differences between noise experts with respect to times at which noise limits should apply. I want to note that Ms. Leach has not had the benefit of reviewing revised noise predictions that were made by Mr. Farron after the applicant has now specified machinery used in the mining activity in response to submissions. So we looked really carefully at how we could reduce noise impacts, particularly along the eastern boundary, and that's resulted in a reduction of machinery used in those areas and also noise effects. There's differences in opinions between landscape experts. Mr. Robinson disagrees that the proposed mitigation measures will avoid, remedy or mitigate landscape and visual effects, and has recommended a broad suite of alternative measures. I just want to highlight there that Mr. Robinson relies on Mr. Payne's assessment of ecological matters in terms of whether that the forest fragments are significant, so that underpins his conclusions. Also, as we've discussed earlier, there's nowhere in Mr. Robinson's assessment that he acknowledges the activity proposed is sort of anticipated. That's that plan context that we were talking about. I say that while it's appropriate to consider the provisions, it's not appropriate to undertake that exercise in a vacuum without reference to the reality of the site being in a productive rural environment. It is important to consider that activities that have some similar environmental effects can occur without resource consent when considering revised mitigation measures. So that's the point I was making about one, context, and then B, the permitted baseline applying to some of those measures. And then finally, I say that some of the proposed mitigation measures focus on the transient passerby, when considering the alternative mitigation measures, it's really important that the panel also consider the neighbour amenity, the engagement that's occurred between the applicant and the community on the basis of that proposed mitigation, and that there has been very limited opposition as a result of that. I have touched upon briefly amenity values and greenhouse gas emissions. I don't think we really need to talk to those unless they come up through submissions, but in short, you can consider greenhouse gas emissions now. The statutory bar's been lifted. Uniquely on the West Coast, there's an air plan that was provided and came into effect that already considers emissions. It's been updated now to include the mandatory policies from the, what's it called, National Policy Statement for Greenhouse Emissions from Industrial Process Heat, but otherwise they still have permissive rules, and this plan, this application meets those rules. The West Coast Regional Council officer agrees that no consent's required, and I've suggested that the fuel emissions are regulated by the emission trading scheme, and that's an appropriate mitigation. One thing I should note is that climate change is obviously a very important issue, and the evidence of the applicant demonstrates that reducing emissions has and will continue to be at the forefront of their planning and operations. But the government has clearly indicated how it intends to address climate change and the tools and mechanisms which it intends to use to ensure that we meet a target of net zero. So no additional resource conditions are needed. In terms of the reduction plans, which need to be incorporated in the regional documents and they're not relevant to consents, I would just note that the latest emission reduction plan for this sector in the transport sector no longer requires a reduction in emissions over the 5 years. The way this government has focused its climate change reduction is on creating new renewable energy as opposed to restricting or reducing emissions in this particular sector. So it's quite different to how it's been previously. And finally, I conclude there is no doubt this proposal will contribute significantly to the economic wellbeing of the community and region, and is consistent with future regional and national strategies for resources. The panel has before them a well-considered and comprehensively assessed project which will appropriately avoid and manage effects during mining and result in long-term benefits to the environment. There has been considerable attention given by the company for its operations and planning, hydrologists, water quality experts and ecologists on how to appropriately avoid adverse effects on the culturally significant wetland and other ecologically significant areas. And there's a willingness of this applicant to continue to engage with the community beyond this process. Finally, the applicant wishes to acknowledge the genuine concerns held by the submitters and to thank them, as well as other parties who have been actively engaged seeking to resolve concerns, for the involvement in this process.
Thank you.
Just a couple. So just in terms of the dust, the application proposes to meet the regional dust rules 3 and 5 by way of a management plan, but I couldn't find who actually wrote the dust management plan. So I'm just wondering, can we consider that as evidence that it will comply with those rules?
Well, the West Coast Regional Council is happy that we comply with those rules. So that would be the first point to make. In terms of the dust management plan, that dust management plan is one that is currently used, or at the base of it's currently used on their 9 Mile site. So it's a company-owned plan that has input from various different experts. I think it complies, the base of it is that it complies with the MFE guidelines on dust.
Right.
Yeah.
Yeah.
Mr. Duncan Ross, who's part of the environment team, he attaches the dust management plan to his evidence and he would be comfortable in answering questions on it. I think we haven't applied for consent for dust to be beyond the boundary that would breach those rules.
Yeah, I suppose what I'm concerned about is even if it is designed to comply with the MFE guideline, you know, who's saying that it does, and who's got appropriate qualifications to say that it does comply?
Well, I would say from a legal perspective, if the applicant has not applied for consent for dust to leave its boundary in a way that would breach those rules, then it must comply with that however it decides to internally.
Okay.
And that if that isn't complied with, they'll either be, the council has enforcement opportunities under the Act, or they will need to retrospectively apply for consent for that.
Yeah.
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 But I'm happy for any specific questions to be obviously directed to Mr. Ross, who knows more about dust than I do.
Yeah, of course. Just the last question, just on fix on the state highway. So one of the submitters has asked for a safe pedestrian crossing to the south of Hokitika and north of the site. So to what extent do we have the power to impose conditions outside the site? And I'm assuming you'll probably say we don't, but if that is an issue that you thought was relevant, is that something that the applicant would get the agreement of the Roading Control Authority, which is NZTA, to do, if you had to?
Yeah, I must admit, I don't know the context and I'd have to defer to Mr. Miller, but in terms of Mr. Fuller, in terms of the applicant's position on the state highway, is that the state highway is obviously existing. It's an existing situation in terms of how the road operates, and that the evidence of Mr. Fuller is that we remain within, the additional movements on the highway from this application remain within what's safe to operate. I understand he's made a bunch of changes to the transport management plan, so I'm going to defer to that. But legally, that's within the NZTA's authority in terms of how they manage their highway. We could offer on a all-year basis a condition for a pedestrian crossing, but those discussions haven't been had with NZTA on that basis, and we would not be in a position to say that they would even agree to that. And I don't think Mr. Fuller thinks it's necessary. Yeah.
Yeah, okay,
Yeah.
thank you.
So it's expert opinion. There have been a number of discussions that have occurred with NZTA since the evidence from the applicant's been lodged, and NZTA, as I understand it, have pulled out of the process and written a letter supporting some conditions that have now been offered by the applicant as part of their 30th of May set of conditions. Yeah.
Thank you.
All right, so it's 12. The schedule says we carry till 12:30.
I've got Mr. Hardy, and he's prepared a PowerPoint that including.
Before we start, we'll check whether the emails come through.
Oh.
Oh, yeah. Download those, give me a moment.
Okay.
So can I just check with you? We have Duncan Hardy presentation slides, Ray Mudgway presentation slides, summary statements of Mr. Ridley, Mr. Cooley, Dr. Bramley, Dr. Fitzpatrick, Dr. Easing, Mr. Ross, Ms. Gillespie, Mr. Ricker, Mr. Ballinghall, Mr. Fearon, Ms. Crawford, Mr. Fuller, Mr. Chase, and Mr. Ritchie.
I'm just saying off the top of my head, but that sounds correct. There should be Mr. Lowe and a link below that. Have you got the email or have they just been uploaded? Should be Mr. Lowe's was 100 pages, I think. So it would have been not sent as a Word version.
Link is further down.
No, I don't have that.
If it's the email that you sent, there will be a link, but I'm not sure how it's been sent to you. Okay.
It's got PDFs.
Oh, you've only got the PDFs?
Yeah.
Okay, so there was in the original email sent a link as well to the planning evidence, which when they say planning, the summary statement with a tracked and a clean version of consent conditions and images that support that.
And we've had an email.
It's actually at the bottom of it. If you scroll down, there's a link there.
Yeah.
No, mine hasn't downloaded that link from Tim.
Oh, right. Yeah, no, it hasn't either.
Don't have the link? No, I think he's
Yeah,
also just sent the,
Password's not working.
oh, there should be a password in the email that has a security code to the link.
So we're waiting for another email, is that correct?
Yeah, I'm anticipating he hasn't just forwarded the email that we've sent and has loaded what he thinks you need, so.
Okay, so just for the record, we also have two documents from Ngāi Tahu as well. Letter and an appendix. So, Tini Ngāi Tahu. Okay.
So the link is on, there's just two documents referred to.
In the link, yeah, it'll be,
Just
it's
pass
the large ones that we couldn't send.
go to that email from Tim. Yeah, and then scroll down. Scroll down. Scroll down. Oh, you can scroll down.
No,
Is it Apple?
yeah,
Oh, okay. Not quite sure. So if you go to mine, it just you can see the previous email. So there's
can you just forward that to me? Or alternatively, I could just see if it's a problem.
I'd say it's just the way Apple's showing that email because it all will be there.
Yeah.
What I'll do actually is I'll just forward you the links, correct? That last email.
Have you put a space in front of it? Because that can be an issue if you make sure you
I'm just copying and pasting.
Have you got it, Tim?
copy without a space. I noticed that when
Tim, have you got it?
there was a space in front of it.
I'm just trying to. Oh, I've just copied. I've just sent the email to you now.
Thanks.
Hopefully that'll be downloaded to the website so everyone will have access to it.
Well, while that's happening, why don't we kick on?
So there's no speaking notes, just the presentation with Mr. Hardy.
I would suggest that I saw he's highlighted his bits of his evidence that he wants to talk to and he'll have some images.
Oh, so this,
But yeah, no summary statement for Mr. Harding, correct. The company witnesses won't have summary statements.
so what we're waiting for is relevant to Mr. Hardy's.
No, no, you should have the PowerPoint slide that Mr. Hardy's got up here. Yeah,
Right, well, let's go from,
I've also got a printing copy if anyone needs one.
right, well, welcome, Mr. Hardy.
Oh, thank you.
Yeah,
Good to see you again.
yeah. So you've got a presentation that you want to go through?
Yes, well, I was a little confused. I thought that the presentation I'm reading from had previously been submitted to you.
Right.
That's not right.
No, it has, it's his evidence.
Yeah, we've read the evidence that you provided.
Okay.
And we have to gracefully decline your invitation to go for a walk with you. But thank you for the invitation.
Alex advised me that would be the case, but obviously no, I'm going to leave it.
Yeah. No, I can see that there was a healthy lack of legal involvement in crafting, which was enjoyable.
All right, well, look, my full name is Duncan Hardy, and I'm the founder of Westland Mineral Sands. I stepped down as chair as from April 1. I do remain the largest shareholder, and also I'm a strategic advisor to the company. I have to say up front, I'm immensely proud of what the Westland Mineral Sands team has done the last presented to you, Mr. Chair. It's over 2 years, but I didn't think we'd be this far advanced, and we wouldn't have had these achievements. We certainly wouldn't have gained the markets that we have and accepted within the mining community. So I'm very proud of what the whole team has achieved. I've often asked why I resigned as the chair. My company, which I still run, Hardy Pacific, is a quite a large company in its own right, spread across the Pacific. Westland Mineral Sands is one, I guess, one part of it, and I promised the initial founders that I had introduced and brought for the ride, and have contributed immensely along the way, that I would give them 3 years. And unfortunately, it lived out 4.5 years. So I've stepped down, and Debbie, who's going to be presenting this afternoon, is moving a far better chairperson than what I would ever be. Moving on, just briefly on Hardy Pacific. Our major project is in New Zealand is carbon mineralisation venture we've got going based in Southland, New Zealand, which I'm very proud of. But we've also got natural hydrogen. We lead New Zealand in natural hydrogen. We've got copper exploration, other critical minerals, and in particular, monazite exploration going throughout New Zealand and other Pacific countries. I've always had a deep natural fascination with minerals and a strong connection to the West Coast. 17, I became involved in the venison recovery business in South Westland. Along the way, I've been commercial fishing, various ports, including Westport and Greymouth. Tourism business in Punakaiki. 3 of my 4 daughters were born in Greymouth Hospital. So along the way, I've been pretty well connected to the coast, and I've been on the West Coast more than any other region in the world. So along the way, I was quite involved with the Greymouth Chamber of Commerce for a number of years. And it's interesting that the 2 big subjects were always ongoing flooding and the fact that the port had closed down. But here we are today, hopefully remedying that. And briefly in 1986, family immigrated to Sydney, along with 12% of New Zealand's population around that time. Wasn't a good time in New Zealand. I was involved in industrial property development, and then I sold out of that business and started the mineral exploration business. Prior to leaving New Zealand, we'd had quite involvement with exploration here and some mining on the West Coast, including pegging a big area in the vicinity of Hokitika. We were initially exploring for gold, and I was aware in that exploration that there was garnets in the in the sands and in the river gravels. And it wasn't till around 2000, when I sold out of the business, I set up an exploration company based in Newcastle, just north of Sydney. And we were exploring in South Australia at the time, in the Strzelecki Desert, which is a very remote area. We were looking for anything we could find to make a dollar out of, but we did find a whole strand lines and an old abandoned seabed of heavy mineral concentrates. There was primarily monazite and other heavy material, but there's a lot of garnet there, predominantly garnet. And unfortunately, garnets weren't worth that much at the time, and this thing was over 1,000, or this site was over 1,000 kilometres from the nearest port. It wasn't economical. But I learned a lot about garnet during that exploration program. So I took a geologist that was with me over to New Zealand, and we had a look at these, and consequently, he said, "You've just got to peg this, it's just such a rich deposit." So we included the garnet into the prospecting permit which we had at the time and started working it up. And that's approaching 20 years ago. So I've been working on this project for a long time down here. And we were always fascinated by the richest part down here, and this area was 146 hectares that we subsequently purchased some years ago, which this application is sitting on 111. So this has been in the pipeline for a long, long time. So at the same time, there was another rich garnet deposit south of Fox Glacier. We also pegged that, and we also bought that farm with another 160 hectare farm, which we still own, and this will be a feeder into this one. So it was always my business to build an intergenerational business on the West Coast based on these deposits, because it was such a vast deposit. It's on par with the largest deposit in Australia in heavy mineral sands. So it does have a life of 100 years. This is from the Fox Glacier deposits, or the Bruce Bay, I should call them, deposit up to north of Karamea. At the production levels we're talking about going to, it's got a life in excess of 100 years. One of the biggest frustrations I had along the way was that New Zealand didn't have a critical minerals list. When I started lobbying the government, this is going back 10, 15 years ago, the critical mineral list, I was very much a lone voice. Virtually all mining was either coal or gold and aggregate. No one was really interested in the rest of the minerals that the West Coast and other areas have. So I probably led the charge for the critical mineral list, which the Minister, Mr. Jones, did announce late last year. And I was an integral part of that all the way through. So moving on to the 9 Mile plant. That 9 Mile, now it's very much in the scheme of things, it's a pilot plant. It's very small by world standards, or by Australian standards. But it's been operating now for over 2 years. It's a plant we bought in Australia second hand, although brand new. It was still in the packing cases. The company that ordered it from South Africa went into receivership, and we bought it cheap. Wasn't ideal for the site, but it proved during COVID, it was very hard to buy any mining equipment. It gives a whole package Westland to go to Westland. So arrived in 24 40-foot containers. Successfully assembled it after we got the consent, and it's been operated for 2 years. So
And is that the plant we see in the
yes,
background?
so in fact, if we go to the next slide, please. This is I think a more close-up image of the plant. No, go back one of the previous close-up. Never mind. We just go back to that plant, the previous plant. You can see the plant in the background. I think there will be some further. Oh, but it's imagine. I think it was 40-foot containers arriving. It was quite a big plant. With included canteens and everything, going into big generators going into modification. It also improved the richness of the deposit up there. Now, all these deposits, and I'll talk later on the geology section, just they're pretty consistent deposits. Some are more dominant in garnet, some are more dominant in ilmenite. Some are thicker than others, but they're predominantly the same material from one end of the coast to the other. So if we just look at that plant, prove that we've got a viable business here. This is our second plant we're building in Mananui. The first plant enabled us to start refurbishing the Westport ports. This second plant will mean we'll have to refurbish the Grey Port because it's the closest port. So we're now facilitating the 2 ports, both that we have long-term leases on. The third plant will be a much larger plant back in the Buller region, but that's for the future. The other interesting concept of the ports opening up, it does also open up a whole range of other minerals which exist on the west coast, which have always been restricted. The most obvious being the aggregate, the sand, which flows out large quantities every year into the sea. There's a big demand for aggregate and sand, particularly on the North Island. The North Island lacks good hard rock like the West Coast has because most of their river gravels have been intermingled with soft volcanic material, and it's hard to distinguish between the two. So, but also looking at the economics, it's appearing feasible to ship aggregate and sand to Sydney and possibly even Singapore. There's a world demand shortage of sand and aggregate. So once we've got the ports up and running, it does open up so many more industries. So the development of the Westland Mineral Sands proven in-ground deposits will ensure the viability of these ports for over a century. Because once you've got a base load for a port, the others you can then develop both inward cargo and outward cargo. But that's for the future. We're pretty concentrated on this stage, just getting, I want to get 1 million tonne of HMC, heavy mineral concentrate, which we'll come to shortly, going out of ports in its current form, no further processes. We don't really want to upgrade it until we've got 1 million tonne. That was always my model anyway. And the restoration of the ports not only increases the region's resilience in the event of a natural disaster, it takes trucks off the roads going across to the east coast, and eventually will open up the possibility of importing fuel and the others and taking more trucks off the roads. So we're very proud of what we're actually now facilitating these ports. So
So this tonnage is taken to another port, or is it going directly?
it'll go to, using barges, it'll take it off to, blue water ships offshore.
Right,
We've subsequently thinking rail covering this. We've got three loading zones, one offshore Greymouth, one offshore Westport, and one in Golden Bay. And you get to the bar right where they thought actually take the barges up and load at the Golden Bay.
right. So these are like big machinery conveyors that just fill up blue water tanks,
Yes,
blue water ships.
yes. Well, actually, in the first instance, we'll be just using grabs, but eventually that's probably where the West Australian model is. It's all conveyors, yes. But we have to start somewhere, but that's in the future.
Hmm.
But we're certainly looking at the future, or some of us are. So we look at the company. We've got a number of companies within the group. You know, we've got a shipping company, we've got a oil company, we've got a land company, and we've got effectively a mining company, all encompassed into Westland Mineral Sands. So there are certainly a number of companies within there, and there's different reasons why we've got the different companies. One of the biggest problems we had when we started this, I had heavy mineral sands experience in Australia and Papua New Guinea. I knew what I was doing, but there'd never been a HMC, heavy mineral concentrate business in New Zealand. So getting staff was experienced staff, because it is a relatively sophisticated business. Just don't dig it up and ship it out. So we put together what we thought was a pretty competent board. We then put some directors on, and I hold both Australian and New Zealand passports. I spent roughly half the time in both countries. But when it comes to mining, I consider myself an Australian. I consider myself a New Zealander in many other ways, but Australians are very good miners. They lead the world in so many mining products, particularly in sand. The biggest sand exporter in the world, over 1 billion tonne a year. So I'm sure that we've got 3 Australian directors. I'll put my hand up on one of the 3 in this instance. And so there's 2 Australians, but we need that Australian experience to get this company going. And the senior, most important employee is Tim Chase. He's also an Australian. He's had many years in the mineral sands business in Australia, Africa, and China, and Asia. But Tim will talk to that later on. But I think it's the bulk of our employees here are locals, but we had to bring in the Australian expertise to kick the thing off. And also in the first instance, it was difficult raising money, and the first money came in from Australia because Australians understand investing in mineral sands. New Zealanders don't. So if we just, the key directors here that we've got at the moment is, of course, Ray Mutway, who's next in line, sitting over there with a grin on his face. Debbie, the new chair. And Cameron, have we got Cameron coming on this evening? Cameron is Australian based, been in mineral sands for a long time. His main claim to fame was bringing on Richards Bay in Africa for Rio Tinto, which at that time that mineral sands development took place, probably 30, 40 years ago. It was the biggest mine in Africa, and it's quite a bit cheaper for Rio Tinto to do that. They had to build their own port, big mine. I think it's still the second biggest mine in Africa. So we've got that sort of expertise on the board now. Ray's got an amazing history in logistics. And we've got another 2 or 3 board members that are more on the governance side. And also Hugh Gray, also on logistics. So we've put together a pretty good team of directors. Debbie in particular brings a new level of governance. I've never been really big on governance because I'm more interested in the nuts and bolts of getting projects out of the ground. But we've reached that stage where we need the level of governance where we've got 60+ employees and all the health and safety and everything else that goes with it. But just coming back to Australia and the experience that I brought from Australia, there's no mean feat to export in excess of 1 billion tonne of sand a year. So this is what 1 billion tonne of sand is like. The plant we've got at 9 Mile has the capacity of producing 100,000 tonnes of sand a year. So imagine we need 10 of those plants, and you'll see that plant when you do the visit, to get 1 million tonne. So imagine getting from 1 million tonne with 10 plants of that size up to 1 billion tonne. Now that includes iron sands, HMC, silica sand, but it's all sand that the Aussies produce each year. There's one port in Port Hedland which puts out 700,000 tonnes of sand. It's hard to imagine how much sand the Aussies use.
Is this for concrete and things like that, or is it?
No, there's iron. Most of it, the biggest bulk is iron sand.
Mm-hmm.
The second biggest bulk is probably silica sand. They also produce a huge amount of bauxite. All the bauxite that comes down to the Bluff aluminium smelter comes from Australia. Bring it down ships. Then we export the bauxite using the green hydropower from Mananui. So you can't knock the Aussies and the knowledge on mineral sands, all sorts of sands. In fact, all sorts of mining. Australia has the reputation of the cheapest mines in the world, whether it be copper, whether it be uranium, sands, coal. They just consistently turn it out. So, and unfortunately, we have to be more competitive than the Australians, and this is because otherwise we can't compete in the world market. Our markets, we're competing against the Aussies. The Aussie consenting process is far easier than what New Zealand says. It's quite embarrassing, difficult and expensive. This process here is costing us in excess of $2 million for all the experts and all the research. The same permit would be less than 400,000 in Australia and take a small portion of the time. So it's a capital cost we're having to carry. And that's one of the reasons there's been this anti-mining sentiment for so long in New Zealand that it's difficult to get it cranked up. They have to give Minister Jones a big tick for trying to make new mining not a dirty word in New Zealand. But at the back of all the directors' minds, we have to be cheaper than the Aussies because we're breaking into their markets. New Zealand labour costs are cheaper, but that's positive. Diesel's about the same, but our deposits are richer. We've got very rich deposits, adding up all the Australian deposits that are close to the ports are primarily being mined out. So the average distance to port now exceeds 500 kilometres for our competing projects, some up to 1,200 kilometres. Whereas our average haulage is going to be about, well, less than 50 kilometres. That's a big cost saving. And we own our own ports. It's also a cost saving.
That might be a convenient time just to pause for lunch.
Certainly, it's the best idea. Have a business district.
It's often said. I don't want to interrupt you because it's fascinating listening to that, but I'm conscious if we don't keep to the timetable, people will feel they can't get.
No, you're the boss.
All right, so we'll come back to that.
At what time do we commence?
We're back again at 1:15. Is that all right?
1:15, that's
Yeah,
fine.
45 minutes.
Good.